Well, hey everybody. Good morning. I see Al. I see Linda. I see lots of hello, friendly faces. I hope you are well. I just have a quick update, and don't. I'm the Chief Justice is going to have the real scoop on SB 11, which in fact was it died. So this is a rare victory for redistricting, and I just want to make that's what I thought I was coming to talk about. But it sounds like you guys have somebody that's like an actual expert in the field, so I don't want to belabor the point. The only thing I'll tell you, real quick update from All on the Line, is that we've we've started our accountability team formation process, and we have our first leadership meeting on May 18th. For those that have been coming to our stuff, that's the first leader meeting. And just to level set with you, it looks like that redistricting is going to be done in Texas probably in special sessions starting in October. So we do have some time to really dig in and get ready for the map drawing that will occur in this state. So the leadership meeting if you haven't gotten a link for that, it probably means that you haven't filled out a survey to get invited to that meeting. So if you were expecting to go to the leadership meeting on the 18th and haven't gotten an invitation, let me know, and I will make sure that you get the information you need to join. The only other real update I had for the group is that I'll tell you what, this has been a long week. I was at the Capitol until 3 a.m. So I'm sorry if I'm a little all over the place, which is why, Sandra, I was like, am I really supposed to be here? Because if I'm not supposed to be here, I should probably not be here. But the only other update I'd have for you is that if you get a chance, and this doesn't really have anything to do with All on the Line, but if you get a chance to drop your representatives a note after this week, they have worked tirelessly to make these voting bills not as bad as they could have been. It's a rare ask for me to say thank your legislator, because I always think they can do more, be better, and work harder. But in this case, what I would say is I've never seen people work so hard to protect the voting rights of Texans in my life. And the reason I went and stayed until 3 a.m. Is the reason I stayed is because I wanted to bear witness to what they were doing, because it was Herculean, it was artful, it was genius political strategy on the floor. And so, although we did not, of course, get the result that we wanted with HB6, you need to know that they did a masterful job. And just the inside scoop, because you deserve the inside scoop, is that they found a point of order in HB6 that was lethal, right? Meaning that Briscoe-Cain had done such a poor job of laying out the bill, of doing the committee work for the bill, that I think they could have killed it. But it would have been a delay. It would have been like they would have sent it back to committee and then brought it back to the House and passed it anyway. The deal they made, in my understanding, was we can either kill this bill and you guys have to take it back to committee and it will be embarrassing, and there, all of the things that go with that, but they would have lost their opportunity to add amendments to the bill to correct some of the worst parts of the bill. So they used their research, they used their legal know-how to almost kill the bill, to strip out some of the worst parts of that bill. Now, those amendments that the Democrats got in, including Ina Minharas, including Barbara Gervin-Hawkins, including your San Antonio representatives, may be stripped out in conference. We don't, I can't tell you if their work will endure. I saw made me very proud to be a Democrat and very proud of the House Democratic Caucus. And again, I'm rarely proud of those guys entirely, but to watch them work together was masterful, and they are worthy of our time and investment in the cause. So that's really it. I mean, I don't have any special, like, I see a couple of people have reached out directly to say, hey, can I get a link? And I'm going to write down your names and make sure you get the information asked for. And I just want to turn it back over on a Saturday morning. Let me just say that we have a lot to be proud of our Democrats, and we're doing the right thing by fighting. So thanks. And we'll be talking to you about redistricting a lot very soon.
Thanks, Jen. Much appreciated for giving us that.
Pose a question
on what's going on at the Capitol on redistricting.
May I pose a question?
Sure.
I've been wondering about the current state of the voting quote reform bill. One of the nastiest parts of the proposal was basically to allow poll watchers to harass voters. Is that in the current version of the bill?
As far as I know, sir, it still is in the current version of the bill, and it is, you're right, it is one of the scarier parts of the legislation, particularly if you add together permitless carry. Yes, it is as of my reading this morning, and I am not a perfect person, but yeah, I think it is.
Bad, bad, bad. Okay. Chief Justice Rebeca Martinez has joined us, and why don't we go ahead and move on to Chief Justice Rebeca Martinez, who's going to talk to us about another issue, evil issue that the Republicans have raised. Chief Justice Martinez, welcome. Oh,
good morning, everyone. I'm Rebeca Martinez. For those I've not had the pleasure of meeting, of course, many of you have seen my face repeatedly for the last 12 years. Seems longer in my campaign trail. And again, I always express my gratitude for this organization's constant support of my candidacy and reelection to the Texas 4th Court of Appeals. As you all recall, back in 2009, for my first run of the court, I ran for the court unsuccessfully. 2010 was the year of the GOP and when it comes to the judiciary. But I got up, dusted myself off, and ran again in 2012 successfully, and joined the court at that in 2013, January 1 of 2013. And last year was on the ballot for Chief Justice. And again, thanks to y'all, I've continued to serve, and I'm able to now. And despite 2 viruses, a pandemic and a computer virus that invaded the IT systems of the appellate courts here in Texas, we've continued to navigate through these extraordinary circumstances and have kept our court and courthouses open, much to many of the stakeholders here. I see some colleagues here like Judge Mary, our formidable DA Joe Gonzalez, and all of us working together to continue to serve the public in the justice system. And forgive me if I miss anyone else, but I see a couple of attorneys too, Joe and Milton and possibly others. So today I've been asked to share a little bit more about what's going on, what's percolating in the second branch of government, the legislature, as it affects the judiciary in particular. And there are, and have been, let's just say, efforts, if not enactments, that will continue to affect the judiciary generally, and this year more specifically, those bills that have been submitted that impact the judiciary specifically. This 87th legislature's regular session, which everyone knows runs from January 12th all the way through the end of this month, May 31st, everything from the state budget, which affects the judicial branch, to healthcare, and certainly the education policy that everyone here has been informed of. So the politics and the impact of the coronavirus behind much of it, we as Texans need to focus on what we need to know about this particular biennial legislative session. And there's much going on. Voting restrictions, of course, are at the forefront, restricting voter participation, transgender students, sports participation, and other hot buttons that certainly send clear signals on what the priorities of the legislature are. And there are others here I'm sure that you've invited to come in and speak to those particularly. And I've been asked to speak about those. One particular measure that was filed earlier this year by Senator Huffman and other measures, both in the House and the Senate, that impact the judiciary in particular. To begin with, I do want to introduce to you, if you don't already know, is a woman now who is who's an attorney and current interim chief of staff for Senator Jose Menendez, Pearl Cruz. Pearl, you want to say hello? I do want to introduce her. Where are you?
Good morning, everyone. Thank you, Chief Justice. Good morning, everyone. It's great to see so many friends, including Mr. Bob Como. Great to see y'all.
So for those of you, again, who don't know Pearl, she's an attorney. She's a graduate of St. Mary's School of Law. She has notable leadership roles that I could spend another 15 minutes talking about, not just her service as editor-in-chief of the Law Review on Race and Social Justice, but has continued to be a leader in addressing gender equity, immigrants' rights, civil rights, and certainly the support of the LGBTQ plus community. She's, as an attorney, has dedicated her educational and legal career to addressing the systemic disparities in our state and federal systems. And I know the senator is proud and lucky to have her in his staff. And but I did want to have someone with her expertise and knowledge of current actions going on the Senate floor specifically, and where these particular bills that I'll be talking about are, and how they might rear their ugly head again during special session and what that means. So Pearl, do you want to say a few words before we get into SB 11 specifically?
Sure, thank you, Chief Justice. And sort of what Genevieve mentioned earlier, this week was a very long week in the Senate. I'll speak first particular to the judiciary bills and then to kind of what happened this week. So one of the bills, aside from SB 11, that affect the judiciary include Senate Bill 1529. This bill would create one statewide Texas Court of Appeals. Unfortunately, it did pass out of the Senate. We opposed that bill. It has been referred in the House. It went to State Affairs. However, that for some reason paused. It didn't get to move forward. This late during the session, that's good news because we don't know if the bill will die. And considering that we only have about 3 weeks, it looks like it may have a slow decline. And so hopefully the bill doesn't move forward. In addition to that, we have HB 1875 by Landgraf. This one creates one particular business court just for the state of Texas. The issue with this bill is that it has been sent to calendars on April 30th in the House. Good news is that it has not been moved to the Senate. It hasn't even got out of calendars, so that one may also die. So I'd like to thank everyone who has advocated hardly against these bills to make sure that they have the pause necessary to ensure that it doesn't move forward. As Chief Justice mentioned, these bills can reoccur. There can always be a special session. The governor gets to decide what goes on a special session. We know there will likely be one for redistricting that needs to be covered. We don't have the census numbers yet. So we imagine a redistricting session, a special session around August, September. So we'll of course keep you all updated on that. The senator's working on a number of bills to help foster youth, to help the elderly from fraud prevention. We actually, y'all may remember David's Law. We actually have a bill that passed out of the Senate that will make sure that there is mandatory training that teachers have to ensure there's a suicide prevention in schools. That passed out of the Senate. We're hoping that it will pass in the House. However, there was news yesterday that the House Public Ed Committee may not be meeting anymore. So a lot has happened this week. I'd like to cover on that briefly. Permitless carry passed on the Senate floor. We debated maybe 9 hours or so. We did our best to slow the bill down, but it did ultimately pass. It will go to conference committee. There are rumors that things may be stripped. In conference committee, as you all know, the House and the Senate are going to meet with each other, decide which amendments they agree on, and then they'll move the bill forward, or they'll have to take it to another committee and go through the process again. So time will tell with that as we go closer to the end of session. We're hoping the bill slows down. We heavily oppose permitless carry in our office, and the SDC did a great job on that. In addition to that, the voter suppression bill passed this week on the House floor. When it was in the Senate, one of the amendments we offered that was acceptable to the author was to ensure that if you were in line before the polls closed, you could stay and you could still be able to vote. The bill originally as filed did not allow that. So what we did is Senator Menendez spoke with the author and said, hey, this is a real concern that we have. And luckily, Senator Hughes, he did agree to it, which we're grateful for. However, there were still, bigger issues with the bill. As Genevieve mentioned earlier, the House Democrats did a great job of trying to add amendments to it. It did ultimately pass. Time will tell with that bill, see if it moves forward. But, House Democrats and Senate Democrats did a great job. The heartbeat bill, Senate Bill 8, and I'm sorry to be the person who gives you all this news, but I want you all to be updated. The heartbeat bill did pass. This will make it harder for women to access their healthcare abortion. So that did pass on the House floor. And unfortunately, yesterday, the anti-trans bill, Senate Bill 29, did pass out of the House Public Education Committee. We imagine that we'll have much debate in the House. If amendments are added, that will go to conference, and we will be ready, willing, and able to defend trans kids. So this is all just what happened this week. We will continue to advocate for you all. If y'all have any questions, I'm going to put my email and my phone number in the chat. Please feel free to contact me. As Chief Justice mentioned, I'm the Senator's acting Chief of Staff and his General Counsel. We are ready, willing, and able to defend you all up there. We're keeping up the good fight, and I'm happy to update you all if y'all have any questions on anything else particular.
Thank you, Pearl. And Mr. Miller, if you could allow me to be a co-host and offer me an opportunity to screen share.
Will do.
Thank you. And in the meantime, just to share a little bit more about the lawmakers, the particular Senate Bill 11, which as Pearl mentioned, has been withdrawn. But this particular bill and what transpired in the last several weeks during session as it relates to it is something that the Courts of Appeal, and now as Chief Justice, I'm a member of the Council of Chief Justices, which is comprised of the Chief Justice of each of the 14 Court of Appeals that is here in Texas. We've been monitoring it. We visited with the bill's author, State Senator Joan Huffman, who's a Republican out of Houston, and who is the drafter, as it will, the author of Senate Bill 11. So a little bit of history and context. The bill, as critics would say, would have consolidated the state's elected appeals court districts, again, as critics would say, in favor of the GOP, and it was withdrawn late Thursday, early April. The bill would have reduced the number of appeal courts districts from 14 to 7. Supporters of the bill said it would increase judicial efficiency by equalizing the workload across the different districts. Senator Huffman herself had argued that consolidating the court districts would reduce the transfer of cases from one appellate district to another. What is transfer, one might ask? In an effort to equalize, as it were, the number of cases that would be assigned to each court and each justice in particular, there have been, let's just say, discussions that were really related to the number of justices and the equal pay that we all get, so that if we're all paid equally, we might as well be doing equal work. It's kind of the sense underlying the idea of transferring cases from one appellate district to another. As one political scientist out of Rice mentioned, it called the bill an extreme attempt at partisan gerrymandering. Basically, an analysis of the new districts had occurred, and it became crystal clear that it appeared to be really an effort to improve the functioning of our judicial system, but it did, in fact, as a result, appear again to bolster Republican chances of winning judicial seats in courts of appeal elections across the state. As you all know, particularly as evidenced by my own election, at the time I ran for the 4th court, it was 6-1 Republican. And it did weigh heavily in favor of Republicans just for the nature of demographics and ballot shares. As that those demographics and ballot shares changed over the course of the last decade, certainly that is reflected in the numbers that the census shows, the census numbers that have already been provided to the president and to those looking into the legislative redistricting, that as we know, Texas has now been given 2 additional districts. So essentially the plan, my election would, currently our court rather, is now 6-1 Democrat. And that came after the elections of 2016 and 2018, and not just at the 4th court, but on other courts as well, the 14th and the Dallas courts, Houston courts, and certainly in most of the urban areas where representation by women and women of color increased exponentially. So essentially the plan proposed by SB 11 would combine the Houston's 1st and 14th courts into a new 6th district. Again, the 14 would be reduced in half to 7. And the new 6th district would have included more of the conservative counties to the north and southwest of Harris County. Dallas and Austin, both largely Democratic, would have been combined into a single new 5th District Court of Appeals. And while largely our now Democratic San Antonio court would have been moved now and joined, as it were, to the new 3rd District Court of Appeals that would stretch initially through the Rio Grande Valley, at least under the original proposal. Oh, we'll strike that. There was not a lot of clarity in the original SB 11, but subsequently, the actual bill that got passed out of the committee had San Antonio Court join with the, well, let me back up. There were several versions. So as the chief, in reviewing the versions that were proposed, one version had us join to El Paso with the Corpus Christi Court. Ultimately, the last version by SB 11 would basically join the San Antonio Court with the Corpus Christi Rio Grande Valley Court of Appeals. So there was a link bill, Senate Bill 1529, also by Senator Huffman, would also remove the ability of the new Austin Court of Appeals to hear cases that involve the state government. So currently, any case, for example, against Ken Paxton or another elected official or against the state generally, or any related issue that were germane to the entire state, those cases would fall within the jurisdiction and are filed in Austin. So this new Senate Bill 1529 would basically remove that ability of the new Austin court to be exclusive, to have exclusive jurisdiction over those cases. Instead, this new 1529, which currently is still alive. And as legislatures refer to it, it has legs. It calls for the creation of a single statewide appellate court that would deal exclusively with these state issues, which essentially, as critics would say, well, it would basically keep Democratic judges from being overly influential in these types of appeals, again, cases related to the state of Texas. So it was an effort, as it was viewed by some critics, to diffuse the Austin Court of Appeals. That court also that would be created by SB 1529, that is still, again, has moved further along in the legislative process than SB 11. It would basically, again, replace that jurisdiction and just make it all, and the total of number of judges on this state appeals bench would be done by appointment only, within other certain eligibility requirements, as well as critics would say, essentially guarantee that it would be, for the most part, appointed by the governor and likely by the Republican, essentially. So back to SB 11, because we'll talk a little bit more about 1529 and where that is. But under SB 11, the number of justices that will remain the same. We've had 80 justices since at least the mid 80s, early 90s, mid 80s. But the net effect of these proposed changes would essentially to move around the appellate court system further to the right. That the Republicans, as we know, fairly dominate the state's two top courts, the Texas Supreme Court and the Texas Court of Appeals. But those two courts, as we know, don't always accept appeals from the lower courts. Unlike the courts of appeal, which hears every appeal, criminal or civil, with the exception of death penalty cases, which goes straight to the Court of Criminal Appeals, we are a mandatory appellate court. So if you file a notice of appeal in my court, we review it. But the two high courts are a permissive court. They must grant your petition for review. So there has been, again, some criticism to whether or not, in fact, you would get any review by, for example, a new statewide Court of Appeals, and whether or not eliminating half of the courts would also create huge areas of jurisdiction with large number of judges over the particular districts that were redrafted. And more importantly, under SB 11, currently the fourth court would be the only appellate court of the 14 who would actually lose 2 seats, meaning place 6 currently held by Justice Irene Rios, and place 7, my former seat that is currently held by the Republican nominee, Justice Valenzuela. Those 2 seats would actually be redistricted out and into, and would join the El Paso court, which right now is a 3-justice member Court of Appeals, and it would then be added with those 2 additional seats. There are 2 other districts that would lose 1 seat, and under the proposed SB 11, there would also be 2 new courts of appeal created, one out of Midland and one in Lake Jackson, where the Senator Huffman also happens to have ties to. So as Pearl said, SB 11 has kind of died, and I will share with you a little quirky event that occurred as it relates to when the SB 11 was withdrawn. So SB 11 was set for decision, and it was going to be on the Senate floor, but then all of a sudden, as I was told, and Pearl can elaborate, excuse me, was that they called basically a timeout, and I'm sure there's a formal name for that, but the GOP decided, let's caucus, I think that's the word. So let's caucus. So all the Republican senators went out and caucused, and as one of my senators explained, yeah, we were just sitting there in the hallway, kind of just waiting, tumbling. piddling our, fingers going, what is going on? I wish I was a fly in that room, caucus room. And all of a sudden it came out and they said, yeah, we're going to withdraw this bill, which is really quirky. And I'll ask Pearl here to explain why that is.
Thank you, Chief Justice. Well, the issue with that is it's very rare to pull a bill down, especially when it's someone who is a chair and a bill that's a priority. So the first 31 bills are typically the lieutenant governor's priorities and priority of leadership. And so to pull that bill down is one, I dare to say sort of historic. I've never seen that happen. A lot of people were shocked by it. But as Chief Justice mentioned, the bill could reappear. It could be in a special session. So while we are, happy with the results, we still remain ready and vigilant of where this bill could go. But yes, it is rare that occurs, that a bill gets pulled down from leadership.
Yes, and as it was shared with me by someone in confidence, that was very shocking that it had occurred, because normally when you caucus, it's really just to kind of fine tune stuff, or maybe let's figure out that we're all on the same page when we get out there in public and start, saying what we say. But the fact that later, and we probably got it fairly much more quickly than about the same time when the media got it, was the letter that Senator Huffman drafted, which also was kind of unusual, drafted saying, we've decided that at this time we're going to withdraw it. And, but word on the street is that there had been concerns, even among the GOP members, about the impact that this redistricting, even though Senator Huffman takes great pains in calling it restructuring, and that's a note, put a little asterisk on it. I'm going to share with you why that is. I think my own little theory is that where was I going with this? So yes, well, let me first tell you about redistricting and restructuring. She has been calling it restructuring, and as we know, as many of you have seen my PowerPoint presentation about the history of the judicial system here in Texas, and how we evolved from a state beginning with the Republic of Texas, where our judicial branch had only basically two levels, trial judges and the Supreme Court. And over the course of a century and a half, the judiciary was restructured by constitutional amendment. It was the constitutional amendment that created the intermediate courts, and it's by legislative enactment that redistricted what was originally the 3 courts of appeal into what is essentially now 14 judicial districts. What Joan Huffman continued to argue basically with Senator Chewy, also both of whom were on during the committee hearing, was he kept saying this is redistricting, and she kept saying this is a restructuring, which was odd to me because restructuring is done by constitutional amendment, and a legislature cannot restructure the judiciary. It can redistrict it. However, as many opponents who came to testify against the bill during committee, including myself and other members of the judiciary, the redistricting is and must comply with the Voting Rights Act. And so to redistrict even a judicial district, and again, what the basis of much of the opposition is that it would become exceedingly more conservative voting bloc, to make districts larger. It's more likely that it would, as one critic said, would incorporate a wider, more conservative demographic on the bench. And as former Justice Alcala, who was the first Latina on the Texas Court of Appeals, first Latina in the Harris County Court of Criminal Appeals, and then subsequently elected as the first Latina on the Texas Court of Appeals, she had worried and also opposed the effective Senate Bill 11 on the diversity of already what had been a largely white bench. And as she said, quote, "It's exceedingly difficult for people of color to be elected, even under the current system, and certainly the proposed system," she said, would have made it and would make it much harder, end of quote. So I digressed on that point. But essentially at this point, let me just give you some graphics about what this district shows. First, let me show you what essentially our system looks like right now. Let me pull this up, which has been essentially the same for, for the last, say, 30, 40 years with the 14 judicial districts. Let me get onto my share screen and pick on this one. There you go. Can y'all see that? Nod, Bob, if you can see it. Very good. So if everyone can see, and it's kind of color coded, this one was a historic map back in 2003. Probably because since we became 14 courts of appeal, there has been some redistricting to avoid some overlap. As you can see, as I point my cursor up here near the 6th, 5th, and 12th, that there are some counties that have some overlap. This was kind of fixed in subsequent maps, but this is just the first map I came across. But you'll see the 13th court is basically Southeast Texas. The 4th court here is the largest judicial district with 32 counties. And many of you have seen that map. I'll show you the one specific to the 4th court. The 8th court is the El Paso Court of Appeals. Let me see if I can increase this just a bit so you can see. There you go. So this is how Texas is currently kind of mapped out currently. How they would propose to change this is into what would now be a, forgive me, here it is. Now this is the map I kind of created that includes make that larger. Can y'all see that more clearly? Pearl, say yes. I can't see anybody because I moved it to screen share.
I think it might have froze, Chief Justice.
Yeah, I don't see anything different.
Okay, tell you what. Let me stop share and start fresh with a new one. How about that?
Yes, much better.
Very good. So as you can see, I remapped what essentially overlaps our current structure, but then showing which counties would essentially be moved out of various districts, specifically the 4th court. So here, as you can see, this is the 4th Court of Appeals. Let me move this up because I don't know if you can see that. So SB 11, as proposed, would propose to make the 3rd Court of Appeals essentially South Texas. It would include the minus 13 counties, which are essentially the hill country, beginning with, it would include Bernie, Kendall County. So if you lived in Bernie and commuted into San Antonio and somehow got into a little accident somewhere, it would depend on where that accident occurred, whether your appeal of that case would go to the new 3rd Court of Appeals that would sit in San Antonio, or whether, but if you had a case that, say, derived from an accident in Bernie or within Kendall County's limits, or maybe something about your school or your property, or depending on the claim, or if you get divorced or you need to probate your will, you would actually have to travel all the way to the Midland Court of Appeals or El Paso. Now recall, Midland is one of the courts that they would create, that the legislature would actually have to find a budget for and build and create a new courthouse in Midland. So these 13 Hill Country, including Del Rio, would now go to the Second Court of Appeals. And we would be here joined by Corpus Christi Edinburgh Court. And we would have two courthouses, but it would mainly, so the justices would remain the same, being able to be housed and have their offices there. However, if an appeal was assigned to the San Antonio court, then the Corpus justices would have to travel and vice versa. So again, the budget issues and how much that would all cost would have been factored in. You can see the Houston two courts of appeals would be joined, and much of these demographics would again create conservative strongholds. There was a bit meandering here. The biggest concern is, why would Austin and Dallas be joined? Well, again, because now it's kind of leaned more democratic. So let's just keep the Democrats within this sort of sliced out, doesn't even look like a state, and carve it around Waco, keeping Waco, Fort Worth, and Eastland top heavy, basically a conservative court. But to begin, you could be driving through Waco and it would just depend on where that case would go. And then the panhandle would remain all the same.
I think that's called cracking and packing. They would pack all the Democrats that they could into Dallas, Austin, number 5, and so on. So that no matter what, you end up with a majority of Republican-dominated courts.
And that's the biggest criticism about this particular bill, because of not just the visual, but the essential the optics of the what would appear a clear intent, which the GOP representatives have said, no, that's not really what we're doing. These maps that they've created echo proposals that have been tried for the last decade or more before the legislature. There has been a movement that really didn't have legs, quote unquote, until now, that has proposed this type of redistricting, a way to basically change the makeup and have a greater impact on the demographics of the courts. And because, again, Democrats were, it was an uphill battle to get a Democrat on an appellate court. But since 2016, certainly 2018, when the Houston and Dallas courts became majority Democrat, our court as well, that has, and the closer that I suppose the two high courts then are likely to be a little bit more diverse politically, that this has gained a little bit more momentum, and particularly in both committee work and on the floor, where the majority party has been able to and is more willing to take advantage of their majority to be able to pass some of this legislation that again impacts it. So one other House bill is 1875, which rumor says that it doesn't have much leg, but it can. I don't believe it had gotten out of committee, as it were, yet, but House Bill 1875. Now, this bill would create essentially a business court and a business courts of appeal. It's again a latest of a series of bills, but it didn't actually pass in past legislative sessions. At least this one to create a business court, I'll call it, since 2015. Again, it would create a statewide specialized civil trial court and appellate court. So there's be a business trial court as well as a business appellate court. And that court would hear derivative actions on behalf of organizations. Those organizations would be defined, but basically corporate entities by business entities and against business entities, between these organizations, and then certain class of individuals, particularly business partnerships, LCs, things like that, relating to a contract transaction, for example, or any business purpose. This business court would be composed of 7 trial judges, again, all appointed by the governor for 2-year terms. The Court of Business Appeals would hear appeals from this business court of appointed trial judges. That Court of Appeals would be composed of 7 justices, about the size of the 4th court, also appointed by the governor for 2-year terms. So the appeals of the business court would go to the Business Court of Appeals, and the appeals from the business court would go to the Texas Supreme Court. Dare I say, as critics have said, that it just appears that it would be a rubber stamping all the way up. So if, as the Office of Court Administration estimates, this court were created, essentially the fiscal impact, which is concerning, and why it hasn't really gotten a leg, I think, is that even just for the first 2 years of operating this sort of secondary court system just for business entities would exceed in the millions, 12, 13 million alone, just in the first 2 years. And we know with the impact of COVID and healthcare and our snowpocalypse and not everything that has been a consequence of that has really kind of affected our state's wallet and the purse strings, and just how much is that going to be available to create this whole business court structure, which is why I think that it might not have considered to have any leg. However, just last month on April 6th, the Judiciary and Civil Jurisprudence conducted a public hearing on the bill. A couple of weeks ago, by a 5-4 vote, the bill was voted out of committee without any further amendment. So it's kind of there, but Pearl, do you have any sort of update from last week about where maybe that, I believe that had fallen, but what do you know?
You're correct, Chief Justice. I think there's a pause right now. We're at that point in session where there's might be a standoff between the Senate and the House. But I think in particular, that bill has paused. If we can keep it paused, then that's a good thing, because then the bill won't move at all and won't have time to move to the Senate. But you're correct, Chief.
Just a couple of related ones. On April 27th, there was a vote in the Senate that passed SJR 47. It was essentially a proposed constitutional amendment. So first the legislature proposes a constitutional amendment, and then of course if it gets past that, then it becomes a constitutional amendment, much like we've had in years past in elections here in San Antonio, well, across the state. This proposal would change the eligibility requirements for certain judicial offices. That seemed to have also passed. There's also other eligibility requirements, like any discrimination against any individual having constitutional rights of their applicant to hold a particular law license. So they're tweaking basically the eligibility of a judicial officer, of basically a judge. And there's a lot of leg about changing the eligibility requirements for judges and justices across the state. Some of them have gotten, concession, basically agreement. For example, changing the eligibility requirements of how many years you must have under your belt. Also adding a restriction that you, as a candidate, you could not have been sanctioned or admonished or been disbarred within a certain time frame, as well as residency requirements. There was also one that concerns me as chief and the Court of Appeals, well, and many others, particularly those that handle a lot of parental termination cases. And I've said this before, that Bexar County, if you were to look at a graph of the parental terminations, those cases that land in children's courts where parental rights are being terminated, if you were to look at a graph, it's fairly constant among the 254 counties and certainly within the districts, but let's just say county-based. But if you went to Bexar, it's a high graph. Bexar County does, for a number of reasons that have been addressed, has an extraordinarily high disparate number of terminations. So typically when you want to appeal from those type of cases, you have to wait until a final order. And then that order is reviewed. There's a House bill right now that has unanimously passed, which would propose to effectively allow various what's called interlocutory orders, or orders that are not the final orders, but orders that are entered throughout the way. We don't hear appeals from those interlocutory orders, but if this bill passes to allow an appeal from all of these orders, those numbers, just multiply them by 7 to 10, that would increase the number of appeals and the disproportionate number of those appeals from Bexar County into the fourth court would also be not insignificant, and taking away 2 seats, leaving me with 5 justices, and then exponentially increasing the number of cases that are eligible for review. That, by the way, also there is a statute, because it involves children, that we must review them within a certain period of time. 6 months from a parental termination, very likely proposed even less time for any of these interlocutory orders, can really cause a burden. So removing our resources, but increasing them effectively by these can have drastic impacts. And I think in large part, and I think this is suffered by every branch of government I've found, is that members of each branch of government have little to no understanding about how the sausage is made in other branches of government, which is why I think it's sometimes difficult for members of the judiciary to really understand how a bill becomes a law, but also legislators having little to no understanding about how the judicial system works, how a case percolates from filing all the way to a final judgment, and then of course into the appellate process. And I think that lack of understanding is what makes this difficult to seek consensus. It is clear, however, that I think in large part, whenever they, for example, caucused about SB 11 independently, word has it on the street that many of the lawyers who are GOP members of the Senate had a better understanding about what impact this proposal under SB 11 would have, as well as I've also understood, is that many of our representatives do feel a proprietary interest and obligation to protect the courthouses and those that serve, everyone that serves in them, to protect them for the benefit of their constituency. And so knowing the impact and consequences to these proposals to their constituents, really they have a better understanding about why something like SB 11 is a bad idea. So there are a number of others bills that I'm happy to share if y'all want to send me. There's a different outlets for one to become very informed about the various bills in both the Senate and the House that impact not just the judiciary, but other education and other areas that you might find interest. But I do want to say also, much to our Democratic representatives, they appear to be proposing matters that, in my opinion, help to improve the judiciary in serving the public. It provides, for example, one, kudos to Representative Ana Hernandez out of Houston, proposed a bill that would require implicit bias training for judges and judicial officers, court personnel, and even attorneys. And so I'll draw your attention, for example, to House Bill 2714, which is that proposal. And it would require different requirements for attorneys and the judiciary. but it would essentially include continuing education, particularly on implicit bias. And the status of that apparently is that it did conduct a public hearing back in mid-April, and but the bill remains pending. So I still find it odd that things that certainly would improve everything, there's still somebody wanting to say, yeah, we don't need implicit bias training. I'm a big proponent of the members of the judiciary to be much more aware and cognizant of the need. And some judges are just, challenged by even acknowledging that we have and suffer from bias. And this bias underscores everything that's wrong with any institution, including the judiciary. And so the more that we can do to be introspective about that and to be active to improve the system, even if it begins with us, that's one bill that I applaud, and hopefully it passes.
Chief Justice Martinez, we have a couple of hands up.
I was just going to invite some questions, but and I've not been monitoring the chat room. So if Pearl has, and if she sees one that she can tackle, I'll invite her to take it on.
Jen, did you have your hand up?
Good. Thank you, Jen. Go ahead.
Well, I wanted to fill in some stuff that judges and senior leadership and senators' offices may not be able to do. SB 11, we were all on the line had created a working group with the NAACP, LULAC, and several other organizations to fight this bill in the House. We had started talking to rural Texas Democratic women chapters to get them ready to call legislators. SB 11 had a tough hill to climb in the House. Rural Republicans did not like this bill because although there would be more Republican judges, they certainly would not be from rural areas. So we had started to organize the troops basically to kill this bill in the House. But because of the sort of ham-fisted process in the Senate where maps were released the night before the hearing, and just if you look at those bills, look, you don't have to be a redistricting expert to see that there were way overpopulated districts, to see that it was going to reduce diversity, particularly in the Latino community, and that it was a way to consolidate power, particularly for urban Republican judges. This was a unique and special failure for the lieutenant governor not to have this pass. And the House parliamentarian had actually insisted from our intel that this bill not go, that it did go to the House redistricting committee because it is a redistricting bill. It was brought up over and over again in the one hearing it had in the Senate. And our understanding is Chairman Todd Hunter, who's the Republican chair of the redistricting committee, did not want to hear this bill. And so what ended up happening, and this is right, like this is scuttlebutt, but see, these very important professional women probably, I'm just a hack, so I can say stuff like this, went back over and let Huffman know that the hill to climb to get this bill even heard in committee was too high. But that happened because judges showed up for that first hearing that Huffman had. And I was there in the hallway, and I will tell you, there were a lot of suits and no t-shirts, which is always bad news, right? In the Capitol, because if you only see suits, it's usually, it's usually not people representing the people, but in this case, it absolutely was. And it's another triumph, frankly, for activity, for people that care about democracy in the United States Constitution. Those judges showed up regardless of party and explained just how bad this bill was and how bad several of these bills were. Never did Huffman or any of these people talk about the cost to taxpayers of any of these bills. Never did they talk to court administration people to talk about splitting districts in such a way that that administrators and judges would have to hear cases between multiple courthouses. And it is an excellent preview, just like the voting bills that made their way through this week, of what to anticipate in redistricting in the fall. And kudos to Menendez's office and so many other folks, but the judges and your senators did an excellent job in asking just the right question. And it was a rare moment of Republicans and Democrats in the House looking at a piece of legislation that just has no business existing, and turning it down. So it was quite something to see. And I would have come back to you guys a lot earlier if this bill had moved farther and said, okay, let's start calling Republicans because I think we can kill it. So that's the stuff that they can't tell you, but that I happen to know. So there you go. That's it.
Thanks, Jen. That's a valuable insight. Okay, Chief Justice Martinez.
Yeah, no, to follow up from what she said, it was a proud moment for us. You know, the impact to each individual Court of Appeals is distinct. And the proposals made under Senate Bill 11 did not draw any consensus about whether or not even the members of the judiciary entirely, even on the appellate level, would, some are okay with it, particularly those that individually might find it beneficial, their ability to be able to stay and be elected on their court. Those benefits were derived by both Republicans and Democrats. Certainly, I will disclose that if the Third Court of Appeals was created, joining us with the Lower Valley Corpus Christi Court, currently the 13th Court of Appeals, we would, our re-electability would increase exponentially because it's a fairly democratic demographic. The ballot share would essentially lean in favor of Democrats, just as much as in some of the other more conservative dominated demographics would essentially be the same for our Republican colleagues on those benches. So some courts and individual justices, again, are like, I'm good with this. There are others, of course, like, for example, the El Paso court, which has tended to lean Democratic, making it very difficult for a Republican to earn the ballot share to be able to get reelected, given that the proposal would effectively join El Paso with Midland, a demographic that is heavily Republican, that even joining them, the ballot share coming from Midland would effectively, the current Democrats would unlikely be able to get reelected, including the newest Chief Justice on the court that joined on January 1 as I did. So the Fourth Court, however, because we were losing 2 seats and because we felt that as a whole, this was something that we felt strongly. We were actually the only court that showed up, all 7 of us justices, and we spoke in one voice before the committee on that day to express our concerns, if not opposition, to the proposed bill. Opened ourselves up to questions about how and why. It was very difficult in 2 minutes to say anything specific, other than, again, generally wanting to implore to the committee the need for our court to maintain the structure it has with 7 full seats. The numbers favored saving those, maintaining the original structure of the Fourth Court of Appeals, and that if part of their bullet points was to maintain experience and avoid any disruption, that removing 2 seats as justification to include, which was essentially about 1/3 of our docket. I believe, and I have nothing to show that this is true, but that, as you can see on that map, they wanted to remove 13, all of our hill country, basically red counties, into the Midland El Paso Second Court of Appeals, new Second Court of Appeals. And so I think they said, well, if we're going to chop off a third of their counties, let's chop off a third of their seats. And it's not justifiable when you look at the demographics and the number of appeals that we get from those 13 counties. Even collectively, those 13 hill country counties provide maybe anywhere between 12 and 16% of our docket. So it's less than a third for sure. But I think that's why I think it's a logical conclusion to say that, well, if you're going to take 13, let's take 2 of your seats as well. Which again was difficult to convey in 2 minutes, but even though it passed with committee, it seemed, even despite as was shared with you, the enormous opposition from so many stakeholders, that it fell on deaf ears, with the exception of the Democratic senators that were in the committee. And as it was testified, they talked about all that opposition. So thank you.
Sandy?
Yes, just briefly, before we move on, would like to know, we are not going to, this is something that isn't going to be going away. And I was wondering, just briefly, what it was you think that they were going to do to alter it in order to make it palatable for the next session.
Well, that's a good question, and Pearl can hop in as well to explain what that means when something goes into special session. But even though it was withdrawn, because as you can tell, SB 11 has a low number. That means it was a priority. If it's got a low number, it's on the front burner for the governor, the lieutenant governor in particular, and the lieutenant governor is very close to Senator Huffman. And so in large part, it's been suggested that that's the driving force behind it. So the fact that it was withdrawn, it is still very likely that it will rear its ugly head in special session, which will occur again. Also, it's also an issue germane to the redistricting, which will also be raised for sure in special session, and it can be added on by the governor and under different scenarios. Pearl, you want to hop in? What does that mean to get in a special session and the likelihood for SB 11 specifically?
Thank you, Chief Justice. You know, right after session gavels at the end of May, the governor has the ability to call a special session on any matters that he finds to be priority of the state that were not covered during the regular session. So what we understand is that redistricting will have a special session because that occurs only once every 10 years. And we did not receive the numbers due to the prior administration and due to COVID. So we don't have census numbers. So no matter what, we know there will be a special session for redistricting. But as Chief Justice said, because SB 11 is so germane to redistricting, it's drawing up courts, it would cover the same code and language. It could technically be tacked on to something. It could be covered in there. It could be brought up. As far as altering the language to I don't know if that's going to occur. You know, the people who would know are the people who are in that room, the people who, you know, during the caucus decided. I don't know, you know, because you still need to have the bill passed, and because there was so much opposition, I don't know that it passes as filed. I think changes would need to occur. So I think we just stay vigilant. I think we see if new language comes out. And as soon as we have that information, we're happy to share with y'all. We have a good relationship with, you know, senators all speak with one another. We do have a good relationship. So if we receive information, we'll share it with you all. But I would say that if this were to come up, I'd say it would more likely come up in redistricting session because we don't know if a special session occurs right after the regular.
Okay, I'm going to have to call this session to a close. We actually ran 35 minutes over time for this, but it is both an interesting and an extraordinarily important issue. What's going to be going on with our courts? If we are going to be seeking justice for everyone, I think it is very important that we have a diverse representation on our court system. And if the Republicans are going to make it so that we have a very non-diverse court system, it's going to make it difficult. Chief Justice Martinez.
Just a real quick thank you again, express gratitude that y'all are interested in it. The sad thing is that these matters have been under the radar for many, and clearly our legislators have their front burner topics, the bills that they propose that they want to run through. But I just want to say that it's really important for me to make the ask that y'all call your representatives, both in the Senate and the House, to say, I want you to oppose these bills. I want you to oppose Senate Bill 11 when it comes up. I want you to oppose the Texas Court of Appeals. I want you to oppose the Texas Business Courts. The Texas Court of Appeals one is the one I believe has leg, and that one is still in play right now. It's very important. I think what we do is we don't tweet, we don't do this, we have to call them repeatedly. So please call, including your Democratic officials, because again, some of them are unaware because they don't have the bullet points, and we're sharing with them bullet points in the hope that they're armed with that information. But for them, their offices to receive repeated calls from their constituency, as y'all know, is what works. So y'all need to please call them and say, we care about our appellate court. We want to keep our seats, because I think someone asked, where do you think it might tweak, where the horse trades, as it were. I think that at the best case scenario is that they take one seat instead of two. I feel like they have the votes to pretty much pass what they want, this legislature. We see that. So we have to call. We have a concerted effort to call. I think those that are lawyers also have a little bit more fine-tuned perspective about it. So please call everyone, including the Republicans, because if they hear that this is going to impact their courthouse, we have a common concern about our courthouses. And that includes, as someone mentioned, Senator Campbell, our other Republican representatives. Please call them and ask them to vote no on these propositions. And that will be very, very important. So thank you very much for your time, Bob. And y'all, everybody stay safe and healthy. And one last one, I noticed that Judge Longoria was here. Shout out to him. My friends, Mr. Romo, and of course, my colleague, Mr. Joe Gonzalez, who's keeping our courthouse safe during these times. So thank you, Joe.
I know you all are trying to wrap up, but let me just say one quick comment, and that is that we are so lucky here in Bexar County that we have such strong leaders in our Democratic Party like Justice Martinez and Senator Menendez and the rest of the Bexar County delegation. So I just want to thank you all for all the wonderful work that you've been doing in Austin. Thank you, Justice.
And thank you. I'll invite Pearl to put her info in the chat room. So if y'all have any information or would like to keep posted, she's the woman to connect with. And again, she's the interim chief of staff and has really been, and one last thing, I give her props. She's also a member of the new cohort at the Women's Campaign School at UT-LBJ, which is, and I'm on the board, and I'm very delighted that she and 2 or 3 other San Antonians, including Mary Ellen Velez, who's with Congressman Lloyd Doggett's office, are in there. So they share that class, and so she's a current leader and a future leader. So she'll be off the bench soon. So thank you, everyone, for allowing us to be here.
Thank you, Chief Justice.